You're sitting at your IWCC arbitration hearing. Your Illinois workers' comp claim has been open for 4 months. Your treating physician's notes are in evidence. And then the insurance company's attorney stands up and says 4 words: "We have surveillance footage." That moment happens in real hearings to real workers in Illinois who have had no idea anyone was watching them. Workers' comp surveillance is not a rare tactic reserved for fraud investigations. Insurance companies authorize it routinely, often within weeks of a claim being filed. Most injured workers never know it's happening when the footage was recorded. If the insurance company later tries to use that video at arbitration, your attorney can object, challenge the foundation, cross-examine the investigator, and argue that the clip is incomplete or misleading. Investigators are not trying to catch you committing fraud. They need footage of you doing something that looks inconsistent with what you told the IME doctor about your limitations. And that inconsistency can be as ordinary as lifting groceries from your trunk or picking up your child at school. What investigators can legally do in Illinois, how footage is used at the IWCC hearings, and why your family's social media accounts are part of this. All of that is in this video. When surveillance starts, most workers assume surveillance, if it happens at all, starts late in the claim, around the time of a hearing or dispute. That is not usually when it starts. For claims over a certain value threshold, meaning anything with ongoing TTD payments, a serious diagnosis, or an attorney involved, insurance companies commonly authorize surveillance early. I've seen investigators deployed within 2 to 4 weeks of the initial filing. The early weeks of a claim are when workers are least guarded. They've not yet been told to be careful. They may not have retained an attorney. They're dealing with their injury, trying to get back to normal, and they're not thinking about who might be watching from a car parked down the street. The surveillance window opens at the beginning, not the end. What they're looking for. Private investigators on a workers' comp case are looking for one specific thing: a gap between how you described your injury and the limitations to the treating physician and IME doctor, and what your actual activity looks like when you don't know anyone is watching. That gap does not have to include fraud to damage your case. It does not have to be dramatic. A worker who describes severe restrictions on bending and overhead reaching could face real problems if footage shows them reaching into the trunk of their car even once, even carefully, even if the movement caused pain the investigator is not recording. The point of the footage is usually not to prove a standalone fraud case. The insurer uses to argue that your activities are inconsistent with your reported limitations. If admitted, the arbitrator weighs that video against the medical records, your testimony, and the rest of the evidence. That distinction is exactly what the insurance company's attorney will exploit. This problem is especially acute at the MMI stage of a claim, when impairment ratings are being established and case value is being calculated. We have a full video on MMI and how it works in Illinois. Footage from earlier in your claim that appears to contradict your limitations becomes part of that argument. I've been in arbitration hearings where surveillance footage changed an outcome. I've also challenged that footage successfully by deposing the investigator and introducing context the video alone did not provide. But you cannot add context to a moment you did not know was being recorded. Legal versus illegal surveillance in Illinois. Private investigators operating in Illinois workers' comp cases have real boundaries. Most stay within those. You should know where those lines are. What is generally legal? Filming you from a place where the investigator has a right to be, such as a public street, sidewalk, parking lot, grocery store, gas station, park, or restaurant. Following you in a vehicle on public roads. Recording video in any location where you do not have a reasonable expectation of privacy. They still cannot trespass, harass you, record private conversations without the legally required consent, or film into places where the law recognizes privacy. What is not legal? Entering your private property without permission to film you. Recording audio conversations without consent. Using deceptive identity to gain access to your home. Trespassing on private property, including your backyard if it's enclosed. In practice, the vast majority of surveillance stays entirely within legal limits and never needs to cross those lines. A backyard with a high privacy fence provides some protection. A driveway visible from the street does not. A front porch visible from a public sidewalk does not. One thing I tell every client after they retain me: the car parked across from your house with someone sitting in it for 3 hours may not be a coincidence. You're not being paranoid. You are being realistic. Social media, your family's posts matter too. You lock down your own social media accounts. That is necessary but not sufficient. Insurance companies and investigators may review public social media posts by you and people around you. And lawfully obtained posts can become evidence if they're relevant and properly authenticated. If your daughter posts a private photo where you appear in the background, if your spouse tags you at a restaurant, if your brother posts a video from a family gathering where you are visible and moving, it can end up in your case file. I deposed a private investigator who confirmed that social media monitoring runs parallel to physical surveillance on most significant claims. They're not just watching you on the street. They're watching your network online. The conversation you need to have is with your immediate family, not a vague mention, but a direct explanation of what is at stake. Lock your accounts, go private or inactive for the duration of your claim, and ask the people around you to do the same before they post anything that includes you. Drop a comment if you're currently on a workers' comp claim and someone in your family has been posting about you. Tell me what happened, and I'll respond. How footage gets used at IWCC hearings. When surveillance footage is introduced at an IWCC arbitration hearing, here's how it plays out. The insurance company's attorney moves to admit it in evidence. Your attorney objects on available grounds. If admitted, the arbitrator views it. We then cross-examine the investigator, challenge the methodology, present your treating physician's complete medical record as context, and argue that the footage does not mean what they say it means. I've deposed private investigators under oath and asked how many days they conducted surveillance versus how many days producing anything usable. Investigators sometimes run 20 days of footage and present one 5-minute clip without disclosing the 19 days that show nothing inconsistent. That context belongs in front of the arbitrator too. The footage rarely wins the case outright, but unexplained, it causes real damage. What to do right now? From the day you file a workers' comp claim in Illinois, assume you may be under surveillance. That is not excessive caution. That is appropriate baseline awareness for any significant claim. Behave in public at all times consistently with what you've been told your treating physician. If your injury prevents certain movements or activities, do not perform those activities where someone with a camera might see you. I'm not telling you to stay inside or stop living your life. I'm telling you that how you behave in public needs to match what you've reported medically. Inconsistency is the risk, not activity. Lock your social media accounts and go inactive or private for the duration of the claim. Have a direct, specific conversation with your spouse, your kids, and anyone else who tags you or posts you about regularly. Explain what's at stake and what you need from them. If you believe you're being followed or photographed, tell your attorney immediately. We can address it, but only if we know about it. And if you don't have an attorney, situations like this are a concrete reason why you should. The insurance company has done this before, many times. The investigator they hired has done this before. Make sure someone on your side has too. Surveillance is one piece of the insurance company's playbook. Closest video to watch next covers what the IME doctor is actually there to do, because the IME and surveillance are often used in combination. That link is on the screen. If you are on a workers' comp claim in Illinois and have questions, our contact information is in the description. Drop your situation in the comments. I read every one.